And Deputy, once we get done with this Hornsby, I'll go ahead and just bring this Casey Lundy, well, I don't know if it's a he or she, Casey Lundy, on Zoom, if you would just bring them in after we're done with her.
All right, I'll get take care of it.
Thank you, sir. All right, this is case number 22, CR 31, State of Ohio versus Lindsay Hornsby. You're Lindsay Hornsby, appearing there from the jail.
Yes, sir.
All right, this hearing is being conducted by Zoom. This Hornsby's attorney is Danielle Witt. She's appearing from her office and appearing from the prosecutor's office, Assistant Prosecutor King. Ms. Witt, you and your client both stipulated this matter to be conducted by Zoom rather than in person.
We are, Your Honor.
Okay. You're on with that, Ms. Hornsby?
Yes, sir.
All right. Ms. Hornsby is charged in counts 1 through 6, it looks like, with aggravated trafficking and methamphetamine, 2 counts of aggravated possession of methamphetamine, 1 count of aggravated trafficking, and 1 count of aggravated possession of each of the fentanyl-related counts. Now, the matter was set this afternoon, but the parties were available this morning as in the court, so we've moved it up here to 10:15. And I've been presented Ms. Hornsby with a plea of guilty form, which indicates you're going to withdraw your non-guilty plea and plead guilty to counts 1 and 3 of the indictment. Now, this is a 3-page form that's been prepared by the prosecutor's office, and so I'm going to hold it up to the camera and show you what it is I'm looking at. It would be as a plea guilty form and your name and case number on there. You can see those items and the 2 counts.
Yes, sir.
All right.
Yes, sir.
And then on page 3 there are signature lines, and there's a sentence that's just about halfway down the page. It says, "I entered this plea voluntarily." And immediately below that there's a signature line that appears to be Lindsay Hornsby. So I'll also hold that up to you, the camera. And is that your signature there at the top line, right below "I entered this plea voluntarily"?
Yes, sir.
And when did you sign this document, Ms. Hornsby?
This morning.
Right, and Ms. Witt went over the document with you and explained it to you, answered any questions before you signed it?
Yes, sir.
And did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
Yes.
You don't feel you've been pressured or rushed in any way into doing this?
No, sir.
And are you entering into the agreement to plead guilty to these 2 charges voluntarily?
Yes, sir.
All right, now on page 1 of the document, it indicates that you're going to withdraw your not guilty plea, plead guilty to counts 1 and 3, both aggravated trafficking and methamphetamine under 2925.03A1, both 4th-degree felonies.
Yes, sir.
Now, but it also states that you understand that the maximum penalty for that, for each count, if convicted, could be 18 months imprisonment, minimum 6 if there's each if the term is imposed. It could be a fine of $5,000, and it could be a license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Now, these charges of convicted of both, if sentenced to prison on both, would be served possession. So, if you plead guilty, court could sentence you to 36 months and fine you $10,000 on these 2 charges. You understand that?
Yes, sir.
And are you facing any felony charges in any other jurisdiction?
No, sir.
And are you on probation, community control, post-release control, or parole for a felony from any jurisdiction?
No, sir.
Now, under the law, Ms. Hornby, if you are sentenced to prison for these offenses, if you're convicted, and once you complete that prison term, the adult parole authority does have the right under the sentencing law to put you in what's called post-release control supervision for a period of up to 2 years. They don't have to do it, but they may. If they do, then you'll be supervised in the terms that they set because the court doesn't have any involvement in that decision process. Now, if you are under post-release control supervision and you violate the conditions that they have prescribed, then on that finding, they can return you to prison even though you served the entire term in the court order for an additional period of up to 9 months for one violation, but there would be a cap or limit of half, whatever your prison term was for all violations. However, if you commit a new felony while under post-release control supervision, then in addition, whatever sentence could be imposed on you for the new felony That judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, or whatever time would be left on the period of post-release control, whichever is greater or more. And if that occurs, that would have to be served consecutively to the sentence in that new case. You understand that?
Yes.
Now, the court is not required to sentence you to prison for this offense. I can impose what's called community control or non-prison sanction. It means instead of going to prison, you can put under supervision of a probation officer for a period of up to 5 years. And that, during that time, if the probation department felt that you were not following the requirements, they would have to file a written notice of that with the court. You would get a copy, you'd be entitled to a hearing, and be represented by an attorney. If the outcome of the hearing was that you failed to comply, then at that time the court would revoke your community control and then sentence you to prison for the 36 months and fine you by $10,000. Do you understand that?
Yes, sir.
All right, now count 1 alleges that on or about February 26, 2021 in Hyden County, Ohio, Caleb R. Leonard and you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance, in violation of Section 2925.03A1. Count 3 alleges the exact language except that the date that is alleged to have occurred, March 7, 2021. So both of those are the charges that we just talked about of aggravated trafficking and methamphetamine. Now, Ms. Hornsby, do you understand what it is you've been charged with in those 2 counts of the indictment, what the state said you did, when, where, how they allege that you did?
Yes, sir.
Do you understand the possible penalties for those charges?
Yes, sir.
Now, have you discussed the nature of the charges, the evidence of the case, the possible legal issues of the case, possible defenses to try to raise a trial, possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with your advice and confidence in this matter?
Yes. Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 2, there's at the bottom, there's 5 sentences that are typed in bold and underlined, so I'll read those. Defendant shall enter plea of guilty to count 1 and count 3. State will dismiss the remaining counts. State defense jointly recommend community control of residential substance abuse treatment. Defendant agrees to repay my money to the Hyden County Task Force in the amount of $260 joint several with Caleb R. Leonard. Defendant agrees to cooperate fully against all co-defendants. That's your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
All right, now, do you hold any, and let me back up. Under the law, the matter of sentence is up to the judge, not the parties. And so even though there's a recommendation that you should get community control, once I've heard all the information that's presented and considered it, that's presented to me, if I decide that's not the correct sentence under the law and facts, I could go ahead and sentence you to term of imprisonment and fine you and need to suspend your license for 6 months to 5 years. You understand that?
Yes, sir.
Right now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
Right now, we have certain constitutional rights, must understand, before it acceptably. First of all, we do have the right to counsel, and Ms. Witt was appointed to represent you. Now, she wasn't appointed simply to work the case out, but to provide any defense that might be available to you under the law that you wish to provide. So, if you decide that you do not want to plead guilty, that you want to defend against these charges, she'll continue to represent you, and that would include having a trial if that's what you want. You understand that?
Yes, sir.
Right now, under the Constitution, you have the right to have a jury trial on these charges, Ms. Hornsby, in which 12 people will be selected from a group of citizens that are summoned for jury duty on your trial. After they were selected, the evidence would be presented, and they'd be instructed on the law. And then that jury would have to decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt on either or both charges. Now, if you decided you didn't want to have a jury trial, but you did want to plead guilty, you can waive the writing, which means give up the right to have a jury trial. And in that case, you would have what's called a court bench trial. And that means that instead of the jury hearing the evidence, it would be the judge that would hear the evidence, apply the law, and decide whether or not the state proved your guilt or proved beyond a reasonable doubt. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Under the Constitution, you have the right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. So what that means is that if you have any witnesses you're uncertain are going to come in voluntarily to request a court order, that's called a subpoena, you have to force those witnesses to come to court and be able to testify if you wanted them to, because they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, sir.
Now, under the Constitution, Ms. Hornsby, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. That is that if there is a jury trial and you do not testify, the judge instructs the jury that because that is your constitutional right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you're presumed innocent until proven guilty of these charges by proof beyond a reasonable doubt of every substantial element of the offense. So, what that means is that the burden of proof isn't on you to try to show that you're not guilty. The burden of proof is upon the state to prove that you are guilty. You're not even required to present any evidence on your own behalf. You may, but you're not required to. But whether you do or not, the burden of proof will remain on the state to prove your guilt or prove beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally, you entered the plea of not guilty. Not guilty plea denied the allegations in the indictment, denied you committed a crime, and exercised or invoked all of the rights that I have just described for you. If you change your plea from not guilty to counts 1 and 3, then that is the opposite of a not guilty plea. That would admit the allegations in the indictment, admit their crime, that you committed that crime. That plea waives, gives up all of the rights that I have just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea is, but with that exception. Plea of guilty would waive, give up the right to have a jury or court trial. Waive, give up the right to confront the witness against you and cross-examine for your attorney. Would waive, give up the right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. It would waive, give up your privilege against self-incrimination because you're saying you're guilty, and that's what you find you guilty. It would waive, give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you guilty. It also subjects you to being sentenced immediately by the court if I decide to do that. And finally, it waives, gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain circumstances, you file an appeal, that would have to be filed within 30 days of your sentencing if you're being filed. You understand all that?
Yes, sir.
And are you a U.S. citizen, Ms. Hornsby?
Yes, sir.
All right, do you have any questions about the charge or the possible penalties?
No, sir.
You understand?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand?
Yes.
Any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes, sir.
Now, is there anything you'd like to speak to Ms. Witt about? I did mention earlier, but if you need to talk with her, I can put you in her into a breakout room for the two of you to talk. No one else will be able to see you here.
No, sir.
You have any questions about anything that I've explained to you today?
No, sir.
And is it your decision, Ms. Hornsby, to withdraw your not guilty plea, plead guilty to counts 1 and 3 in accordance with the plea agreement that we've just gone over here?
Yes, sir.
All right, then as to count 1, which alleges that on or about February 26, 2021 in Highland County, Ohio, Caleb R. Leonard and you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance in violation of Section 2925.03A1, a charge of aggravated trafficking in methamphetamine, a fourth-degree felony, carrying possible prison term between 6 and 18 months, and a fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Count 3, which alleges that on or about March 7, 2021 in this county, Caleb R. Leonard and you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance, violation of Section 2925.03A1. Also charged with aggravated trafficking of methamphetamine, fourth-degree felony for the same penalties as count 1. How do you plead?
Guilty.
All right, thank you. All right, the court finds that on this day of the court, defendant applies to all the constitutional rights made in no intelligent voluntary waiver of the same pursuant to Article 11. Please accept the order filed. Defendants found guilty of counts 1 and 3 as charged under and fourth-degree felony. Counts 2, 4, 5, and 6 are dismissed. As to this defendant, the court orders a pre-sentence investigation. The court will include the assessment for substance use disorder treatment and or mental health assessment. Sentencing will be April 13th at 9 a.m. Bond will be continued at this time. All right, is there anything further, counsel?
Actually, Your Honor, I had just learned that Ms. Hornsby has a bed available at the Recovery Council on March 8th, if the court would furlough her to be able to start that treatment.
All right, I will not furlough her, but I'll grant, what I'll do is, Hornsby, is I'm going to, reduce your bond to an OR, your own recognizance, which is your promise to appear. And if you don't appear, you could be prosecuted for additional felonies. So I'm going to reduce your bond to an OR on the condition that you go to and remain at, is it Lincoln, you said?
TRC.
What's that?
TRC.
Oh, TRC, the Recovery Council, all right. So that is in Pike County.
Pike, yes.
So you will, I don't know if it's going to be Georgia Harris or the other house, but whichever one it is, you'll be released to go there on an OR, and you have to remain there. Now, it's not a jail, it's not a lockdown facility. You walk away from that, or decide you're going to leave and tell them you're leaving, then you have to come back to jail, because your OR is contingent upon you being there. If you do not do that, then a warrant will, if you leave there, a warrant will be issued for you. Not to mention the fact that, it may make it much more difficult for you to get community control or probation if you do that. Okay?
I will not.
All right. So, bond reduced on condition that you go to TRC on March 8th, you said, Ms. Witt?
Yes, Your Honor.
Okay. And remain there during pendency of the case. All right, anything further?
No, Your Honor.
All right, I'll give this to my assistant. She'll have an entry ready for the on today. All right, thank you, counsel.
Okay, thank you.
You can guys sign off, all right? I'm going to rein in, I'm going to rein Miss Lundy, Casey Lundy. He or she.
So you don't need me, Your Honor?
Done. Thank you. All right, are you Casey Kyle Lundy? I didn't hear you.
Yes, sir.
All right. This is case number 22 CR 55, State of Ohio versus Casey Kyle Lundy. Mr. Lundy, you were indicted by the grand jury on Tuesday on a charge of breaking and entering and 2 counts of theft. The count 1 alleges that on or about December 14, 2020 in Highland County, you and a Dusty Allen Taylor did knowingly by force, stealth, deception, trespass in an unoccupied structure to win an outbuilding. Purpose to commit therein a theft offense as defined under ORC 291302A1 or felony. So that's a charge of breaking and entering under 2911.13A revised code. Fifth degree felony. Count 2 alleges on or about the same date in the county that you and Mr. Taylor did for purpose to deprive the owner of Corky's truck equipment of property, only obtaining clear control over an international turbo core and exhaust system and other miscellaneous items without their consent, and then had a value of over $1,000 under $7,500. And count 3 alleges on or about the same date that the two of you with purpose to deprive the owner of tax keep of their property, and only take control over that property with catalytic orders and other miscellaneous items without their consent. That's a misdemeanor of the first degree. Now, the first 2 counts carry a possible prison term if convicted between 6 to 12 months and fine of $2,500. And then the third count is a first degree misdemeanor carries a possible sentence of convicted of 180 days in county jail and a fine of $1,000. Now, you're entitled to have an attorney to represent you in this matter. If you can't afford to hire one, will be appointed. So you have to fill out a financial disclosure form. Is everything on this correct? Is everything correct, Mr. Taylor, on your form? Or Mr. Lundy?
Yes, sir. I was actually sentenced to a program in Warren County.
Yeah.
And
Right now you're here, so, all right. Now, you have not had an attorney previously in this case, right?
no, sir.
All right. So I will appoint Attorney Jacob Wagner to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. I'll set a bail review hearing Tuesday morning. That will be the 8th, right?
Yes.
Yeah, the 8th at 8:30 a.m. First street trial will be April 13th at 1 o'clock. Final pre-trial will be May the 4th at 1 o'clock. And trial will be set for May 23 at 8 a.m. Actually, I think that may be wrong. I think it's going to be a week later. May the 30th at 8 a.m. All right. Now, I see you were in Warren County and they brought you up here, so you say you're sentenced to a program where?
I was sent to Genesis, a program,
And when are you supposed to be there?
Monday, as far as I know.
Okay. I see we still have the 23rd, the trial date for that, and then we'll do my vacation that week. So, okay. Yeah, and so let's make that trial date May 30th. Okay, let's change, make that May 30th the trial date for criminal trial. And well, is that all?
Oh, yeah.
All right, so it'll be May 31st then. All right, so Deputy, the trial date will change to May the 31st. 30th is
May 31st.
yeah, 30th is Memorial Day.
Memorial Day.
All right, bond will be set in the amount of $2,500. plus your own recognizance, which is your promise to appear, and if you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that, regardless of what happens in this case. You'll be under pretrial supervision of the probation department, 117 East Main Street. I have to report to them immediately upon your release, you make bond. Report to them once a week for 4 weeks, and after that, as they determine under the random drug testing they may order. Provide phone numbers for home, cell, and employer. Have no contact with alleged victim. Have no contact with your co-defendant. Recommend by probation you'll be evaluated for substance abuse, mental health issues, and treatment indicated control and follow that. You'll also be under house arrest at your residence, wherever that may be, which means you have to be there unless you're working, going to and from work, medical appointments, court proceedings, in this or any other case. Points for the attorney probation officer, this or any other case. You also be attending kind of educational programming or church services. So you'll be held in jail until at least Tuesday when we have the final hearing, and then I'll decide whether or not there may be some things that go. But I had never heard of Genesis until yesterday, or not, actually Wednesday, and we had a lot of problems getting information from that on one of our first people that went down there, and so I'm not going to cut you loose to go there until I know more. So, because what I see here is you were were on probation, and felony was being committed this felony while you're under control of that case, so it might be an issue. So anyway, we'll notify your attorney, and we'll see you then Tuesday morning at 8:30. You have any questions?
No, sir.
All right.